as it has been used for those who pose a high threat. Some classifications of mental illness, developmental disabilities, or chemical dependency, they can lock you up and throw away the key and keep you there without a charge. This is crazy. What about the Constitution? As the teacher said, to be incarcerated without a charge, without a conviction of a crime, is a violation of the Constitution.
I mean, you would think so, but it seems like the Supreme Court said that you can still do it, and something just doesn't seem right about it. Seems like there can be some kind of double jeopardy or something along those lines.
Well, in 1997, it did go to the Supreme Court in Kansas versus Hendricks, but the United States Supreme Court ruled that it is not double jeopardy. So I just feel it wasn't argued with the maximum amount of understanding. That they obviously did not understand what is going on. This is a business enterprise that is deceiving the public and using these men, and they feel that the public won't do anything because they're calling them sex offenders, they're calling them sexually violent predators, but the public doesn't see that that is so fake.
So can you all kind of walk us through a little bit of the mental health professionals, quote unquote professionals that evaluate folk in this catch-22 situation? And you talk about the costs. It seems like it was like the I don't know, the mental health industrial complex or something now. You know, it just seems a situation wherein you can never get out from under it because the people who are making the rules or making the decision as to whether you are cured, quote unquote, to come out, don't really have a vested interest in you getting out. Can you all kind of walk us through that psychiatric portion of this civil commitment scenario?
Go ahead, Phil.
Sure. Well, I think there's a lot to be said on that. So we'll maybe walk through the process slightly here. So in the cases of the two young men that we're talking about this morning, they were both held, they both served time on nonviolent sexual offenses. These were consensual interactions which were illegal because of the age of one of the parties. That's how they get sent away. So what happens though, then you go, if you're caught up again, if you have a probation violation, something like that, they've got you again. So then Virginia, they use a screening tool they call the Static 99. This is an incredibly retrograde, ridiculous device. So among the questions are, how old were you? There's a bias if you're younger, if you're under 35 years old when your offense was committed. If you have never had a long-term relationship with someone, which is hard to do if you serve prison time, another strike against you. I know that well. One of the things that held against Galen, if your so-called offense was involving a person of the same gender, you get another strike. All of a sudden, you're screened out and you're a sexually violent predator by that first screening. So then they said, okay, we're going to file a petition based on
even though your initial offense was not violent?
Yeah, yes. Both of these cases, they were nonviolent. So then the next step is that in Virginia, the state, basically the mental health authority, is supposed to appoint a psychologist. And they're generally a low-level sort of master of social work person who will review a file. Most people who are caught in this will not speak to the psychologist because they know it goes against their interest to speak to the government psychologist. So they will make a report based on a review of the file prepared by the government. It's now news that generally speaking, they find, oh yes, this is a sexually violent predator and we need to go forward with these proceedings. And interestingly, the case of Galen Bauman, the psychologist appointed by the state of Virginia found he was not a sexually violent predator.
And she was a PhD.
So after that decision, the state attorney general said, well, that's not very good. So they went out and hired their own psychologist, who did not even read the first psychologist's report, but came back and said, oh yes, never mind, he is a sexually violent predator. And Galen got thrown into this whole mess for another 2 years, based on the opinion of one person. Further, in the court system in Virginia, the judge has allowed this. This is very clearly against the statute, against the procedures that are supposed to protect defendants caught in this position, doesn't matter. He says, no matter, he's a sexually violent predator. So all your sort of due process rights are eroded constantly through this process. So you get to the point where you really have very little left. In Galen's case, that Garnett didn't get a chance to say, he actually was tried as a sexually violent predator 5 years ago?
Yes,
6 years ago.
2020.
And a unanimous jury found he was not. In the intervening years, he has not committed a new offense. Yet, they've said, well, we're gonna take another shot at this. And now he is sitting in a jail cell for 3 years, awaiting trial, yet again, for offenses, for basically based on offenses they committed before he was even 20 years old.
But Nkechi brought it up, my son did a TED Talk, a TEDx talk that's on our website, adjustfuture.org. Where Dr. Thompson and I have started an organization, Just Future, and we're the Just Future Project. So it's www.justfuture.org. There is so much information on there about this, including the TED Talk. I want everyone to go and actually start educating themselves. On the sex offender registry, just throwing this out, Bryce, 1% of Black American men in the United States, as of 2016, have the label sex offender, which means they're vulnerable for this.
I'm looking at some stats that say nearly 5,400 people are currently civilly committed in sexually violent predator programs in 20 states. This is unbelievable. Anytime you can talk about pre-crime preventive detention, this is like somebody with a crystal ball is saying, I'm predicting that you may commit a crime in the future. And because of that, we can hold you indefinitely. There's men locked up right now, been up for years, some for life, for not committing a crime after serving the time. And the Constitution states that you should not be convicted or incarcerated unless you have the conviction of an offense. You serve your time and you can't get released. We're gonna come back and we're gonna take a break and come back and deal with this particular question. What can families do for those men? Are women involved in this too, convicted?
Very few, but it looks like it's a burgeoning industry for them. That's the next targeted, that they're gonna start looking at women. But right now, currently,
Yes, ma'am.
they've mostly been going after
We're
men.
gonna take a break and we'll be right back with that. Yes, this is quite a topic. Pre-crime preventive detention. Man,